My name is Sulbha Sankhla. I'm the founder of Nexus Law. Today we are here to discuss some common mythbusters about estate planning.
So, I commonly heard that estate planning is only for the wealthy. Is it true?
Estate planning is for everyone. Estate planning just helps you prepare, control, and create checks and balances on what happens when you are gone, right? So it not only helps you decide inheritance, it not only helps you decide what goes to your loved ones, but even during your life, how your healthcare decisions would be made. Can you be put on ventilator even though there is no assurance of life? All those decisions can be made through estate planning. So it's a myth that it's only for rich. It's for anybody who has even modest amount of assets. It helps them create guardianship for their minor kids. It helps them create any avoidable expenses, and it helps them make sure that the loved ones get those assets without any undue restrictions or hassles.
Myth number two, I'm too young to need an estate plan. Is that true?
Well, life happens and accidents happens at any age, right? And what people don't understand and realize is that at 18 you're adults, but that also means your parents can't take decisions for you anymore. So do your parents have power of attorney and healthcare in their name? If no, well, you need planning.
Myth number three, once I create an estate plan, I never need to look at it again. Is this even true?
Well, life happens, and with life you get a better job, you get married, you get divorced, you have children, you get old. And your plan needs to mutate and upgrade according to your life circumstances. So, no, you need to work with your attorney every 2 to 3 years to make sure that you have accounted for your new assets and the growth of your assets during the time. This is when you come to Nexus Law.
Myth number four, a will avoids probate.
Wow. I don't even know where to start. Okay, probate is the court process through which inheritance is decided or distribution of assets of the deceased is decided. You have to take the will to the court and complete the probate process for the assets to be distributed in the way you wished. So, in another way, will needs to go through probate process. If you don't want to go to probate or avoid probate, then you should think about doing a revocable living trust. And that's why you would come to Nexus Law.
Myth number five, everything will automatically go to my spouse or children.
True, but maybe not true. Because in your will, you will specify who those assets go to. Without a will, the state laws applies. But also depends on who goes to the court. If I do not go to the court and my family doesn't go to the court, then there is no automatic distribution of assets. So somebody needs to start that process. And if there is no will, then if the state provides for those uh, gifts to or inheritance to family, only then such inheritance would happen. So always make sure that your state laws aligns with your expectations.
So, a lot of people think wills are DIYable, like I can just write my wishes on paper and it will be valid. Is that even true?
Uh, must be coming from the movies, right? Well, you need to have a proper legal document written in a format as acceptable by law. So there needs to be few things which should be included in your document to make it valid. Moreover, if it's a handwritten, not notarized will, it's not most of the times acceptable by the court. And there will be a long litigation, lot of additional evidence or witnesses required, and there can always be dispute over that will. So always make sure that you at least follow a proper legal document as per your state when you're writing the will.
And finally, if I have a joint bank account, I do not need an estate plan.
Well, the joint owner do have the right to use the account, But what happens if both you and the joint owner does not survive? You do not build any contingency in that joint bank account. Moreover, if any assets need to be transferred, then that transfer does not happen just because somebody is named as a joint bank account holder. That ownership is only for and limited to that bank account. So you still need a complete plan for all the other assets to pass through. Just one joint account is not going to validate your intention for all those other assets. Hope this helps you, bust some myths, but please reach out to us with any questions you would like us to answer. We'll try to have them answered in our next reel. See you.